Welcome, everyone, to the Assembly Committee on Commerce and Labor. Secretary, please take roll.
Assemblywoman Backus. Assemblyman Carter.
Present.
Assemblywoman Duran. Assemblywoman Hardy. Assemblywoman Howdigi. Assemblywoman Kasama. Assemblywoman Monroe Moreno. Assemblyman O'Neill. Assemblywoman Torres. Assemblyman Yeager. Assemblyman Urick. Chair Marzola.
I am here. Can you please mark members present as they walk in? Welcome, everybody, today here to Carson City, anyone in Las Vegas, and anyone listening over the internet. Before we get started, I have a few housekeeping rules. Please silence all of your electronic devices. If you wish to testify, please sign in at the table by the door. For those joining online, please be sure to mute your microphone when you're not speaking to minimize any background noise. When testifying, please turn on your microphone and clearly spell and state your name and any affiliation, if any, for the record. Then turn your microphone off each time you're done speaking. We expect courtesy and respect in our interactions during this meeting, even if we do not agree. Committee members will be using their laptops to view handouts and other documents. Please do not let that be a sign of any disrespect. Let's get started. I will now open the hearing on Assembly Bill 22, which revises provisions governing the issuance of cease and desist orders for unlicensed activity by the State Contractors Board. Today we have Margie Green, Executive Director of the Nevada State Contractors Board, presenting from video conference in Las Vegas. Ms. Green, please start when you're ready.
Thank you, and good afternoon, Chair Marzola and members of the committee. My name is Margie Green, that's M-A-R-G-I-G-R-E-I-N, and I am the Executive Officer of the Nevada State Contractors Board. I have with me today also Dave Bihar. He is our Director of Investigations. I'm here today to testify in support of Assembly Bill 22, which outlines the process the board must adhere to when issuing cease and desist orders. The board is required to issue cease and desist orders pursuant to NRS 624212 to any person acting as a contractor or submitting a bid without a valid Nevada contractor's license. Current law segregates the authoritative actions of the board following issuance of a cease and desist order based on the board's determination of a contractor's compliance. The proposed language in Assembly Bill 22 continues this authority, but in a more direct manner, which we feel will help streamline the process and better clarify potential options to address unlicensed contracting activity. Under the single procedure set forth in this bill, the board, regardless of the person's compliance with the order, is required to either issue an administrative citation and impose an administrative fine or report the violation for possible criminal prosecution. Following issuance of a cease and desist order, Assembly Bill 22 retains the existing authority of the board to consider requiring the person to submit an application for a contractor's license, or if the person is not compliant with the order, the board is to apply for injunctive relief through Nevada Rules of Civil Procedure. This bill eliminates distinctions in existing statutory procedures that are based on the number of previous violations and the value of the unlicensed work. To help set the context of this issue, the board has issued 924 cease and desist orders over the past 3 years. There were no instances in which a cease and desist order was issued and the person failed to comply. In the majority of cases, the individual received an administrative citation or had their case filed with the district attorney's office for criminal prosecution pursuant to NRS 624700. Among these, it is estimated that approximately 90% reflected unlawful construction work that was either abandoned or completed with workmanship concerns noticed and reported by the homeowner to the board. It should be noted that there have been several large commercial construction projects in Nevada where unlicensed contractors were utilized as subcontractors. Once the board was advised of the unlicensed activity, the board took appropriate action in the issuance of a cease and desist order to the unlicensed contractors, while also issuing a citation to the general contractor for contracting with an unlicensed contractor. Again, I would like to make it clear that AB 22 simply realigns the existing authority of the board under NRS 624212 to provide a single procedure subsequent to the issuance of a cease and desist order that is consistent with our authority under NRS 624700 and 624710. The Nevada District Attorneys Association has proposed an amendment to the bill that requires the board, after issuing a cease and desist order for the first-time offender, to issue an administrative citation pursuant to NRS 624341 and impose an administrative fine under 624710 in addition to reasonable investigative fees and costs. Additionally, for a second or subsequent violation, or for a first violation where fraud or theft occurred, the board is to report the violation to the respective district attorney for possible criminal prosecution in accordance with NRS 624700. If the violation is prosecuted, the board would be required to aid in the prosecution. The board would also seek to add a provision allowing for the option of criminal prosecution of a first-time offender with multiple cases and/or in cases where the victim was a senior citizen, 62 years of age or older, as defined under NRS 439.650. The board looks forward to working with the NDAA and other concerned parties in amending Assembly Bill 22. And at this time, unless there are any questions, I would like to ask David Behar, our Director of Investigations, to provide you with some specifics on some cases.
Go ahead when he's ready.
Good afternoon, Chair Marzola and members of the committee. My name is David Behar. I'm the current Director of Investigations for the Nevada State Contractors Board. I'm here today to provide testimony in support of Assembly Bill 22. The Nevada District Attorney Association has proposed an amendment to this bill that requires the board, after issuing a cease and desist order for a first-time offender, to issue an administrative citation pursuant to NRS 624341 and impose an administrative fine under NRS 624710, in addition to reasonable investigative fees and costs. If this proposed amendment is accepted, the board's again seeking to add a provision that allows the option for criminal prosecution for first-time offenders with multiple cases or in cases where the victim was a senior citizen. As an agency, we're entrusted with the responsibility of protecting the health, safety, and welfare of the public. I wish to highlight several examples of why the board is seeking to include this language that would allow for prosecution of first-time offenders. In December of 2022, the board received a first-time offense complaint against an unlicensed contractor for abandoning a project involving two seniors who were ridden with a variety of significant health issues, which included dementia, strokes, and severe respiratory matters. During the course of the investigation, it was learned that an unlicensed contractor received approximately $14,000 in funds from these homeowners for the removal of mold at their residence in April of 2022. During the initial process at their home, this unlicensed contractor conducted extensive demolition throughout their property and alleged to the homeowners that they had uncovered significant water leaks which needed immediate attention. As a result, this unlicensed contractor conspired with a licensed contractor to complete this work at the residence. Shortly thereafter, the licensed contractor conducted additional demolition at the location, which resulted in the residence becoming completely uninhabitable and infested with rats. In addition to the money that was paid by these seniors to the original unlicensed contractor, the senior homeowners were then pressed to pay an additional $12,000 to the licensed contractor in hopes of having their residence ultimately repaired. Once this additional payment was received, however, both of these contractors completely abandoned the project and left these two senior homeowners without a livable residence. As a result of this extreme example, the two seniors were forced to move into a small casita in the rear of their property for an extended period of time, and during this time, they were without the use of running water or even the necessities to accommodate their health problems. The board took measures to try and assist these individuals during this process, and this ongoing investigation is currently being reviewed for potential prosecution. A second example I'd like to bring to your attention involved another first-time offense committed by an unlicensed contractor. In this occurrence, the unlicensed contractor entered into a written agreement with an individual who had limited mobility due to a past leg amputation in January of 2022. As part of the agreement, this homeowner paid approximately $235,848.81 to an unlicensed contractor for work that included a variety of plumbing, electrical, gas, cabinetry, painting, drywall, framing, wall coverings, and other necessary requirements. During the course of that investigation, the unlicensed contractor significantly damaged the interior of this homeowner's residence to include the destruction of their stairwell in the house and a safety barrier of a single-person elevator that was being used by the occupant to move between floors within their home. Due to the fact the project was ultimately abandoned, this homeowner was then required to retain a third-party group to assist with completing additional repairs that totaled close to $500,000 to their property. In this instance, the unlicensed contractor was issued a cease and desist order, and the case was referred to the district attorney's office and is currently pending prosecution as well. As illustrated by these examples in my testimony, the severity of significant harm and financial loss to members of the public can easily arise from first-time offenses, and therefore the board asks that language be included in AB 22 to allow for prosecution of these first-time offenders when the situation warrants such a measure. The board looks forward to working with the Nevada District Attorneys Association and others regarding AB 22. Thank you for your consideration, and I would also be happy to answer any questions if you have any. Thank you.
Thank you for your presentation. Now we'll go to questions for committee members. Mr. Speaker.
Thank you so much, Madam Chair. I'm not sure if this question is for Ms. Green or it might be for the District Attorneys Association because it does relate to the proposed amendment. So looking at the amendment, I think the first part makes sense that there would be an administrative citation, restitution would be included. But my question is on the second offense, or if it's a first violation for theft or fraud, it looks like the requirement is to report the violation for possible criminal prosecution. So my question is, what if a criminal prosecution doesn't result from that reporting? Does the board still maintain the authority to assess an administrative fine or fee? Just wondering what happens on the back end in a second or a first involving theft if there really is no prosecution. Is this a way that the board hands it over to the district attorneys and then the decision is made there, or does the board have the ability to do something if a district attorney declines to prosecute?
David Behar for the record from Nevada State Contractors Board. To answer your question, when the matter is moved over to the district attorney's office, if for some reason the prosecution is declined, we don't move forward with anything following that.
Vice Chair.
Thank you, Madam Chair. Nice to see you, Ms. Green. I have a quick question. If I could have probably two questions, Madam Chair. This is the third session where I've seen a cease and desist bill before, Commerce and Labor. So can you kind of walk me through, because I believe the language that we're actually removing from the bill was language that I think we implemented in 2019, and now it looks like you're removing your statutory authority to assess a fine on a contract or on an unlicensed person who's doing work. And so why would you be removing your statutory authority to fine? And I think this is language that was recently added maybe just 2 sessions ago. That's part one. And part two, again, can you kind of walk me through the evolution of what's happened over the last, this is being the third session, because we've seen this exact same statute now changed 3 sessions in a row. This would be the 3 sessions. So can you let me know why the need to change a statute that we just changed last session?
Thank you, Vice Chair Hodeggy. Margie Green for the record. Yes, to answer your first question, we would still have the ability under Section 1, paragraph, I guess that's paragraph 3, that we state that after issuing a cease and desist order, the board shall either issue an administrative citation or report the violation. What we're seeking to achieve with this bill is that we have the opportunity to do one or the other. Often what happens when we issue an administrative citation, the unlicensed contractor ignores that. It's simply there's no penalty. We can turn it in for collection if he doesn't pay that. We cannot order the contractor or the unlicensed contractor to make restitution to the victims. So in certain cases, we would like that ability to turn it over to the district attorney's office for prosecution. But we would still, the way that I interpret the bill, we would still maintain that ability to issue the administrative citation with the fines and costs. To answer your second question, yes, when this bill was put in place in 2019, and it came about because of a commercial construction project in Reno, where the bill at the time, I believe it was Senator Daley, Assemblyman Daley at the time, that put the bill in. We worked with him on it. We determined that we would give it a little bit of a trial period to see if the bill worked. Last session, 2021, we went back to Assemblyman or Senator Daley at the time, explained to him our concerns and how it was not working, because there's little we can do if they don't pay the administrative citation. It's simply a fine. However, if there's a little bit more of a heavy hammer, and as some of the cases that Mr. Behar indicated, where they're going to be a criminal prosecution, because in our minds this is, in a lot of cases, a crime, then that's more of a deterrent for the unlicensed contractor. So last session, I believe, we again tried to work with the district attorney's offices, and I believe the public defenders on a compromise. We were unable to achieve that, and so the bill did not pass. And this is similar to the bill that we had in 2021.
Go ahead.
Thank you for the follow-up, Madam Chair. Okay, thank you, Ms. Green. I think that answered my question. I just wanted to make sure that you guys still had the ability through that administrative citation to issue a fine. And maybe I'm missing it, but I don't see it in here. Is there a limit to how much the citation can fine the person? And if that fine is collected, does that money go into the Victims of Crime Fund?
Thank you, Vice Chair Hodeggy. The amounts of the fines issued for administrative citations is contained in Nevada Administrative Code, and I believe it goes up to $50,000. And that money does not go into the victims fund. It doesn't. The homeowner that hires an unlicensed contractor is not eligible for the recovery fund. Those fines go back into the state.
Assemblywoman Backus.
Thank you so much, Madam Chair. Thank you, Executive Director, for presenting today on this bill. And I think you kind of already answered one of my questions that I was going to ask you. So kind of be a statement, so it's caught in the amendment, is under that Section 1, Paragraph 3A. It includes for the Nevada State Contractors Board as a part of the administrative citation to include restitution, but it sounds from your testimony that it would be preferable that the restitution go to the district attorney for handling instead of having the board handle that, because that would obviously be separate from the residential recovery fund. Is that my understanding?
Margie Green for the record. Yes, Assemblywoman Backus, that is correct.
Go ahead.
And along those same lines, with respect to Section 1, Paragraph 3B of the proposed amendment, I noticed in there was theft, and I just wanted to make sure, because, and this may obviously be a conversation to be had with the district attorney's office, was just to make sure, because some of the ones you were talking about where unlicensed contractors are engaging in deals, sometimes those are quite large and they'll collect a lot of money up front and not do the work. And hopefully that is included in the theft and that could be referred to the appropriate authorities. And that was kind of one of my questions, was kind of make sure that catch-all gets in there for those first violations.
Thank you, Margie Green, for the record. Yes, Assemblywoman Backus, I would ask that you ask the district attorney's office for clarification on that, but I believe that is the intent.
Committee members, any additional questions? I don't see any. Thank you for your presentation. We will now hear testimony in support of Assembly Bill 22. Each person will have 2 minutes of testimony. If anyone is here in Carson City, please come up. We do have 4 chairs.
Good afternoon, Chairwoman Marzola and committee members. Chase Whittemore for the record, representing Nevada Builders Alliance. We support the bill as written. I have yet to review the proposed amendment, so I will do that and follow back up where and if necessary. Thank you.
Good afternoon, Brian Reeder on behalf of the Nevada Contractors Association. Same testimony. I support the bill as written. Need to review the amendment. Thank you.
Good afternoon, Josh Hicks with McDonald Carano on behalf of the Nevada Home Builders Association, the Southern Nevada Home Builders Association, and the Builders Association of Northern Nevada. We support this bill. Unfortunately, there are bad actors occasionally in the industries, and we support giving the Contractors Board more authority to go after those bad actors. So thank you.
Anyone else in Carson City in support of Assembly Bill 22? I don't see anyone. Anyone in Las Vegas in support of Assembly Bill 22? I don't see anyone. Broadcast, is anyone on the phone lines?
To testify in support of AB 22, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in support of AB 22 at this time.
Let's try this again. Next, we'll hear testimony in opposition to Assembly Bill 22. I see several individuals walking up here in Carson City. Go ahead and start when you're ready.
Thank you, Chair Marzola, members of the Assembly Commerce and Labor Committee. My name is John Jones. I see lots of similar faces in here, familiar faces, but for those who do not know me, I represent the Nevada District Attorneys Association here at the legislature. And I do appreciate the Executive Officer Green and the Contractors Board for working with us on our amendment. We're not quite there yet in terms of an agreement, but I do think we'll be able to get there. I do want to say, over the last few sessions, we here at the legislature have had numerous conversations about what conduct properly belongs in the criminal justice system. And in 2019, as was referenced by Leader Howdigate, Assembly Bill 27 was passed, and it was passed unanimously in both houses, 42-0 in the Assembly and 21-0 in the Senate, which took first-time violations of the unlicensed doing business without a license and the contracting board statute out of the criminal justice system. And we feel that that is where those offenses properly belong, unless there are fraud or theft elements present. And granted, I don't know the full facts regarding the 2 cases that were testified to today, but considering some of the facts that we heard, I think you could make an argument that theft or fraud were present. For example, if somebody is holding themselves out to be a licensed contractor when they are not, in fact, a licensed contractor, and that induces somebody to sign a contract with them, that is fraud. If somebody accepts $10,000 worth of a bid and only performs $2,000 to $3,000 worth of work and then leaves, that is theft. We want those cases. Those cases are properly in front of the criminal justice system. The other cases are the ones that we don't feel for a first-time violation are proper in front of the criminal justice system, and that's sort of the dynamic that we're working with here. But again, I want to thank the Contractors Board for working with us, and those conversations will continue.
Thank you. Go ahead when you're ready.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. It's a rare situation where we're on the same side with the Nevada District Attorneys Association testifying in support of a bill. We did a lot of work last session, as Mr. Jones said, to fix that. Both of those examples that the Contractors Board just talked about sound like crimes to me. They could have immediately been referred. But where we did see our system get clogged up, where we took it out as those first-time violators, then you have me and Mr. Jones becoming contract negotiators. And for my lawyers, I think maybe unless you do contract law regularly, then we're arguing about a term called quantum merit. How was the work done? Was it done up to par? Where did they negotiate it? Sometimes people hire unlicensed, this is a dirty little fact, sometimes people hire unlicensed contractors because they're cheaper, right? And they do that. Well, I know they're cheaper. I don't do that because I want to be able to sue, one, if the work is not done right, and two, I want to know the contractor has a bond so that I may recoup some of the money that I lost. So we think the Nevada District Attorneys Association's amendment strikes the right balance in this, and we would ask that the bill not be passed without this amendment. Thank you.
Thank you for your testimony. Go ahead.
Good afternoon, Chair and members of the committee. My name is Erica Roth on behalf of the Washoe County Public Defender's Office. I echo the sentiments of my colleague, Mr. Piro, and do agree that it's not always that we are on the same side as the district attorneys. What was described is a crime, and the only thing I'm going to add this afternoon is I want to put a story in front of you of a client and a case that was tried in Washoe County in 2022. And in that case, an individual, a client, was a handyman, and he put himself out as a handyman. He was very clear to a client that he was not a licensed contractor, that there was certain work that he absolutely could not do, and that client of his still wanted him to do it. He was capable of doing that work. He did the work well, but that work, he made clear that he was not going to do that work, and she begged him to do that work. After he did the work, completed the work, she told him that he did work not as a licensed contractor, that she was not going to pay him, and then she claimed that he assaulted her. Now, this interaction was caught on camera. The entire interaction was filmed by another individual there, and that case went to trial. He was charged with a felony assaulting an elderly person. He was found not guilty at trial, but his life was absolutely upended. He was brought to jail. He had a child, his fifth child, on the way during the pending of that case. And so I put that story in front of you to remember that, as the law exists right now, if a crime is committed against somebody because they put themselves out as a contractor and they commit fraud, there's nothing right now that precludes a prosecutor from bringing a criminal case. But let's also remember that people are choosing, right, to pay individuals who are not licensed contractors to do certain work. And so as the law stands...
Ma'am, can you conclude your testimony,
Absolutely.
please?
Thank you, Chair. We would recommend adopting the amendments as provided by the District Attorneys Association. Thank you.
Thank you. Anyone else here in Carson City in opposition to Assembly Bill 22? I don't see anyone. Anyone in Las Vegas in opposition to Assembly Bill 22? I don't see anyone. Broadcast, is there anyone on the line in opposition?
To testify in opposition of AB 22, please press star 9 to take your place in the queue.
Good afternoon. My name is Jim Hoffman. I represent Nevada Attorneys for Criminal Justice. We are in opposition to this bill at the moment for the reasons echoed by the other people testifying in opposition. I also wanted to raise a concern. I know that Governor Lombardo has talked a lot about the need to look at how we license people, make sure we're not putting up barriers to people's participation in the economy. The fact that people need to be licensed for building contracting, that's an important safeguard to make sure that our homes are safe, that the work is done correctly. But I think in the spirit of Governor Lombardo's call, we need to be really careful about how we do that. And we need to carefully consider whether civil sanctions are appropriate or criminal sanctions. And we believe that in many of these cases, criminal sanctions are not appropriate. And so we are currently in opposition to the bill, although we are hoping to change that. Thank you.
Thank you for your testimony. Broadcast, is anyone else on the line? Broadcast, is anyone else on the line? Okay, we're going to move on to neutral testimony. Is anyone here in Carson City wishing to testify in neutral on Assembly Bill 22? I don't see anyone. Is anyone in Las Vegas wishing to testify in neutral position in Assembly Bill 22? I don't see anyone. Broadcast, is anyone on the line wishing to testify in the neutral position? One minute recess, please. We are currently having some technical difficulties, so recess is going to be a little longer than 1 minute. Broadcast, are you on the line?
Hi, Chair. Yes, I'm back on the line. Apologies. We had some internet connection issues on my end. Are you able to hear me?
I am. Thank you so much. We're in recess for a minute. Thank you for everyone's patience. Broadcast, is anyone on the line in opposition for Assembly Bill 22?
If you would like to testify in opposition of AB 22, please press star 9 to take your place in the queue. Chair, it appears that we have no additional callers for opposition.
Do we have anyone on the line wishing to testify in the neutral position?
To testify in neutral for AB 22, please press star 9 to take your place in the queue. Chair, it appears we have no additional callers, no callers for neutral at this time.
Thank you, Broadcast. Ms. Green, would you like to give any closing remarks?
Thank you, Chair Marzola, and thank you to the committee members for letting us present this bill today. We are happy to work with the other parties on a workable compromise on the amendment and look forward to presenting this to you at a later date. Thank you.
Thank you. I will now close the hearing on Assembly Bill 22. I will now open the bill hearing on Assembly Bill 23, which revises provisions relating to the resolution of certain administrative citations issued by the State Contractors Board. Ms. Green, you may start when you're ready.
Thank you, Chair Marzola and members of the committee. My name is Margie Green, that's M-A-R-G-I-G-R-E-I-N, and I am the Executive Officer of the Nevada State Contractors Board. I'm here today to testify in support of Assembly Bill 23, which expands the existing process for the resolution of an administrative citation to allow individuals the opportunity to request an informal conference with the executive officer or his or her designee for the purpose of reviewing the alleged offense and proposed penalty. Between fiscal years 2020 and 22, a total of 1,173 administrative citations were issued to both licensed and unlicensed contractors. Approximately 5 of those resulted in contested cases. Currently, NRS 624 does not provide a process by which an individual can seek an informal resolution or settlement. Pursuant to NRS 624351, the board is required to hold a formal disciplinary proceeding should a person choose to contest any portion of an administrative citation. Under AB 23, individuals who receive an administrative citation by the board would have 15 days to request an informal conference if desired. The requested conference must be scheduled within the following 60 business days by the executive officer or a designee. Resolution of the citation may be agreed upon during the conference, including affirmation, modification, or dismissal of the allegations. Should the citation be amended or affirmed, an individual would still have the right to contest a citation formally within 15 business days by requesting a hearing pursuant to NRS 624345. It is anticipated that the process proposed in Assembly Bill 23 will reduce the current number of contested administrative citations that are adjudicated through the formal hearing process, as well as reduce costs incurred by the board and the respondents in these cases. If passed, the board would ask that the effective date be changed to October 1st and not upon passage as currently drafted. Additionally, I would like to note that the Associated General Contractors Nevada chapter has approached us concerning a potential amendment to the bill, and we look forward to working with the AGC to address any concerns. At this time, I would be happy to answer any questions you may have regarding Assembly Bill 23.
Thank you for the presentation. Committee members, does anyone have any questions? Mr. Speaker.
Thank you, Madam Chair. My question is, and you'll forgive me, I'm not super familiar with the process when these are contested citations, but I guess here's the question. When someone contests it, are those hearings subject to the rules of evidence and all of that sort of stuff? And the reason I ask that is I just wondered if that's the case with this informal meeting that happens, if you're not able to resolve it, are there any concerns about, somebody incriminating themselves in the context of what kind of sounds like a settlement conference or maybe an attempt to negotiate? So just wondered how those two work together.
Thank you, Mr. Speaker. Yes, in Assembly Bill 23, if it goes to a hearing, then nothing that would be discussed during the settlement conference would be included in that hearing. And we follow the Administrative Procedures Act in all of our hearings, so nothing would change if it went forward with that. However, if the citation is modified during that process, we would issue an amended citation or notice of hearing if they contest it. Thank you. Oh, and I'm sorry I didn't identify myself, Margie Green, for the record.
Thank you. Committee members, any additional questions? I don't see any, so I will open up for testimony in support. Anyone here in Carson City wishing to testify in support of Assembly Bill 23?
Good afternoon again, Chairwoman Marzola and the committee. Chase Whittemore for the record, representing Nevada Builders Alliance. Definitely support this concept. Little crazy to think that you can't go in and request an informal conference to begin with, and that we have to put this in statute, but I think it's a good idea. Provides another layer to go in if there was a mistake or if the contractors board didn't have all the facts on a citation, go in, request a informal conference and try and resolve it that way before having to go through a full appeal. So we appreciate it and look forward to supporting this further. Thank you.
Good afternoon, Madam Chair, members of the committee. Josh Hicks with McDonald Carano on behalf of the Nevada Home Builders Association, the Southern Nevada Home Builders Association, and the Builders Association of Northern Nevada. We support this bill, same reasons we've talked about with AB 22. The enforcement of Chapter 624 is important to the integrity of the construction industry. This bill helps provide some efficiencies that will allow the Contractors Board to do its job, and we support it. Thank you.
Thank you for your testimony. Anyone else in Carson City in support? Anyone in Las Vegas in support of Assembly Bill 23? I don't see anyone. Broadcast, is anyone on the line?
To testify in support for AB 23, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in support.
Thank you. Anyone here in Carson City wishing to testify in opposition to Assembly Bill 23? I don't see anyone walking up. Anyone in Las Vegas wishing to testify in opposition? Broadcast, is anyone on the line?
To testify in opposition of AB 23, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in opposition.
Thank you. Anyone in Carson City wishing to testify in a neutral position to Assembly Bill 23? I don't see anyone. Anyone in Las Vegas wishing to testify in a neutral position? Broadcast, is there anyone on the line wishing to testify in a neutral position?
To testify in neutral for AB 23, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in neutral at this time.
Thank you. Ms. Green, would you like to give some closing remarks?
Thank you, Madam Chair, members of the committee. Margie Green for the record. Thank you for allowing us to bring this bill forward today. And again, I look forward to working with the AGC on if they have a proposed amendment. Thank you.
Thank you. I will now close the hearing on Assembly Bill 23. 1 minute recess.
The committee will now come back to order. I will now open the hearing on Assembly Bill 110. Chair Marzullo, when you're ready.
Good afternoon, Vice Chair Howdigi and committee. I'm Elaine Marzola, representing the Assembly District 21 in Clark County. Assembly Bill 110 makes revisions governing and dispensing and the delivery of certain dialysate drugs and devices used to perform dialysis at a residence. This bill pertains to the delivery of home dialysis supplies and devices to end-stage renal disease, ESRD, for patients in Nevada. There are 700 ESRD patients in Nevada that dialyze at home. To conduct their dialysis at home, these patients need a continual delivery to their home of various dialysis drugs, supplies, and devices. Currently in Nevada, the State Board of Pharmacy is now requiring a pharmacy that only distributes dialysis, supplies, and solutions to comply with the same difficult requirements as a retail pharmacy, like Walgreens or CVS, that handles controlled substances, compounds, and dispense medications with varying safety profiles. Since the manufacturers of home dialysis supplies and devices offer a limited product portfolio and follows all quality and the United States Food and Drug Administration requirements, additional retail pharmacy mandates are burdensome to the operation. This bill would amend the Pharmacy Practice Act to allow manufacturers of home dialysis drugs, supplies, and devices to be exempted from the pharmacy licensure if they maintain control of all products from manufacturing to the patient. This bill will still require the central pharmacy to maintain any additional licenses, such as a wholesale license. With your permission, Vice Chair, Susan Fisher with McDonald Carano, representing Baxter Healthcare, Elizabeth Stahl, Director of the State Government Affairs for Baxter Healthcare, and Vincent Hanks, General Counsel for Baxter Healthcare, will provide a testimony of the bill and the proposed amendment, which has been uploaded in Nellis, and answer any questions that the committee members may have.
Welcome, Ms. Fisher.
Thank you, Madam Vice Chair, and thank you, Chair Marzola, for introducing or allowing us to introduce this bill through here. Susan Fisher with McDonald Carano, and I'm representing Baxter Healthcare today. We do have on the phone Elizabeth and Vincent, and we have the last 4 digits of their phone numbers already in the queue, I think. So what I'll do first, since Ms. Marzola has given you a good overview of the bill, I'll just walk through the bill section by section. Section 1 allows for dispense and delivery by a third party directly to the patient for self-administration. Section 6 has definitions, and there is also a friendly amendment in Section 6. This was requested of us by the Nevada Society of Health Systems Pharmacists, and they just wanted us to clarify that these dialysate drugs mean a drug that is not a dangerous drug, so that it's safe for a patient to use at home. And so the amendment says in Section 1, subsection 6A, dialysate drug means a drug solely composed of fluids, electrolytes, and sugars. And those fluids are typically just saline. Moving on to the next part of the bill, the part of Section 1 also allows for third-party logistics providers to be able to transport from the warehouse to the patient the solutions and equipment. Section 3.5 sub B sub 3 adds the ESRD language to the current list of bona fide and approved sales. And then we move on to the main one. Section 6 also addresses record keeping. It just makes sure that everything that goes from the manufacturing plant to the warehouse and then on out directly to the patients, that everything is fully recorded and provided to the state as well, to the Board of Pharmacy. I think a lot of this was already covered. Baxter has been operating with this model in Nevada for over a decade, well over a decade, but recent review of statutes by the Pharmacy Board said, well, we think we need to have something clear in statute to say that it is all right for you to transport directly to the patient from the warehouse, because at first they were wanting us to have, they said that under current statute, they felt like we needed to have a pharmacist on site in the warehouse to double check that these things were going to the right patients. And these are very large boxes, typically 500 to 1,000 pounds of the solutions. And this is so that the patient doesn't have to go to a hospital or clinic 3 times a week for the dialysis. I'd be happy to answer any questions, or if we have some really technical questions, we've got the experts on the line. Thank you.
Thank you. And so were Ms. Stoles and Mr. Hanks only online to answer questions? Okay, perfect. Committee members, I know I have a couple questions, but I am going to go to the committee members first. Assemblywoman Monroe Moreno.
Thank you, Madam Vice Chair. Just to make sure that I understand it clearly, this medication is not being produced in a warehouse. It's simply being packaged to be shipped to the patient, correct?
Susan Fisher, for the record, that is absolutely correct. It's produced in a manufacturing plant in Illinois, and it is shipped to the warehouse, which is in Dixon, California, and that serves both the California patients and the Nevada patients, 700 patients here in Nevada. And I will add also that this is already being done in 34 other states, and in some format or another. There are 24 states that exempt these warehouses from having to have an additional pharmacist on site because it's already reviewed by a pharmacist at the manufacturing plant. And then another 8 states also have they have some special licensing for them to be able to do this without having a pharmacist on site. And this language mirrors the Model Pharmacy Act from the National Board of Pharmacy.
Okay, I do have a couple of questions. I'm just going to piggyback off what my colleague asked, but is there any way to quantify how much this will actually save Nevadans by just passing this? Like, will it save them, like, monetarily money by not having to go in and do the dialysis physically at a location?
I'd like to, Susan Fisher, for the record, I'd like to call a friend. Could we have either Liz or Vincent?
Sure. Sure, this is Elizabeth Stoll with Baxter Healthcare. I can get you the numbers of the difference of what in-center dialysis versus home dialysis on a broader scale as it relates to hospitalizations, decrease in hospitalizations and transportation and non-emergency transportation and things like that. The way that it's paid for by Medicaid, it's usually paid under a bundle rate. So the actual cost of the therapy is going to be very similar, but there are significant difference in outcomes, medical outcomes as well as financial outcomes when people do dialysis at home versus in the center.
Thank you for that. And that leads me into my follow-up question. So it seems like a very cost-effective way for people to be able to treat themselves. And my question is, why is it limited to only people with irreversible renal failure? Why isn't it available to anyone who maybe needs dialysis, but it isn't a permanent?
Susan Fisher, for the record, I'll probably...
That's a good question. Oh, so sorry.
Go ahead, Elizabeth.
Sorry. This is Elizabeth again. You are correct. There are some places where the actual verbiage, end-stage renal disease, could just say or just say renal. I mean, you're correct, because there's people that have acute renal failure that do dialysis, and they do dialysis at home, but it's not considered end stage because their kidneys are going to recover. Then I'm going to call on my other colleague, Vince Hanks, who is the leader of all of our pharmacies across the country. And he may be able to, I don't know if you have a little bit of insight as to how this distribution model works when somebody is not diagnosed with end stage, but more acute. Is there a differentiation, or is there a need to differentiate in the language, or is that just an understood nuance within the disease state? Vince, do you know? You may be on mute.
Mr. Hanks, apologizes to broadcast to unmute, press *6.
Yes, my apologies. Vince Hanks, pharmacist with Baxter Healthcare. So to my knowledge, we do supply supplies for home, patients to perform home dialysis in an acute setting. So we can amend the language. It's not only for, end-stage renal disease.
It's very rare for somebody. It doesn't happen often, and as you mentioned, short-term treatment. But I don't believe that there's a barrier for us to deliver to those patients.
We have
I hope
patients.
that answers your question. Yeah.
Well, yeah, and thanks once again. We do have patients that, are only on dialysis for a short time. So yeah, we do run into this situation exactly. whether they receive a transplant or they recover enough. One good thing about most of our dialysis is it does preserve residual kidney function, so that option is open to them.
Okay, thank you. And I just have one last question. Is there any dialysate that isn't made up of like fluids, electrolytes, and sugars? I know that it was a friendly amendment, and I appreciate seeing that in there. So I was just curious too, like if there was different types of dialysates that were available on the market.
Susan Fisher for the record. Yes, there are. There are some that they may have heparin in them. They may have insulin in them. Some other drugs that are considered dangerous drugs.
And so this bill would only apply to those made with electrolytes, water, and sugar.
Susan Fisher for the record. That is correct.
Thank you. Committee members, any questions before we move on to testimony? Okay, thank you for your presentation. I will now ask for anyone who's testifying in the support position to approach in Carson City. We will start with Carson City, then move to Las Vegas, and then to support on the phone.
Good afternoon, Vice Chair, members of the committee. My name is Jimmy Lau with Ferrari Reader Public Affairs representing DaVita today. We wanted to say thank you to the bill sponsor and the bill proponents for making sure that we were well informed about the concept and lodge our support in today's hearing. Thank you.
Good afternoon, Madam Chair, members of the committee. For the record, Jessica Ferrato here today on behalf of Fresenius Medical Care. Fresenius supports AB 110 and the amendment proposed. Fresenius Medical Care provides care for thousands of Nevadans who rely on life-sustaining dialysis treatment in the state. Patients who need dialysis may have the option to receive treatment in their own home rather than at an outpatient dialysis center. Choosing home dialysis can mean greater scheduling flexibility, fewer food restrictions, and has shown strong outcomes. Home dialysis treatment can also be done longer and more frequently, which is gentler on the body, meaning patients feel better and have an improved quality of life. Patients who qualify for home dialysis go through a rigorous training program, which includes home assessment and meetings with the patient's entire dialysis team. Once on home dialysis, patients continue regular check-in meetings with their care team at least once per month, support through a clinic, and 24/7 access to assistance should they experience issues. Depending on the type of home dialysis they are receiving, there are different drugs and medical devices that they need to be regularly delivered to their homes. AB 110 removes the need for a licensed pharmacist to be in the warehouse when the package arrives in Nevada and removes the need for patients to go to a clinic or pharmacy. Packages will be delivered to patients as they were sealed in the licensed pharmacy in Illinois, as mentioned. I just thought I'd touch on a couple of things, Chair, because you asked a few questions that I think I can provide some background. So you asked about the dialysate. So some of those medications are often given to the patient separately. Like if you're in a clinic, it'll be given separately outside of it. Oftentimes, if those patients have more serious needs with insulin or other care needs, they'll often be in an in-clinic setting. So that's one piece. I think the other question that you asked was really about acute care patients. So typically speaking, an acute care patient, when they have sort of a sudden blunt acute kidney failure, they're getting that treatment in a hospital setting often. And then let's say they have to do dialysis for a short period of time before rather their kidneys recover or they're eligible for a transplant, they'll often go to an inpatient setting. So traditionally, the at-home dialysis is for patients that are tending to be on it for longer periods of time. It's a commitment to them and their caretaker to be able to do this, but it does provide substantial quality of life improvements. I know you asked about cost savings, but for these patients, it's a very demanding treatment, and enabling them to be able to do this at home and maybe potentially travel if they want to, depending on the modality that they do. It really does, the outcomes are really good from a health standpoint as well as just life quality for these patients. I'm here to answer any questions. Thanks.
Thank you, Ms. Ferrato. Is there anyone else in Carson City wishing to testify in support? Okay, we will move to Las Vegas. Is there anyone in Las Vegas wishing to testify in support? BPS, could we please check the telephone line?
To testify in support of AB 110, please press star 9 to take your place in the queue.
Good afternoon. For the record, my name is Adam Porras on behalf of the Nevada Society of Health System Pharmacists. I've been a practicing hospital pharmacist in our state since 2006. NBSHP is supportive of AB 110 and the overall concept of removing barriers to patient access to dialysate medications when it doesn't pose a potential undue risk to patients. I appreciate the consideration of the proposed amendment to AB 110 that I believe better clarifies the scope of medications that would be included in the definition of dialysate drugs. Many adjunctive medications can be added to dialysate, some of which are considered at the highest risk for medication error, things like insulin and a blood thinner called heparin, which was mentioned previously. When these medications are added to dialysate, it's important not to create a pathway to potentially circumvent the direct oversight of a pharmacist's review of dialysis prescriptions at all stages of the medication dispensing process in order to keep our patients safe. NBSHP believes that the proposed amendment prevents a broader application of the term dialysate drugs to dialysate, including these high-risk additives and other dangerous drugs that can be used in association with dialysis. Thank you for your time and consideration.
Thank you for your testimony. BPS, next caller, please.
Good afternoon, members of the committee. For the record, Liz McMenamin Retail Association in Nevada. I called in to offer my support. I have been representing the Chain Drug Council for many years now, and in listening to the testimony on this legislation, I feel like this is much needed to free up a pharmacist from having to sit in a warehouse and have that pharmacist better use of their education put to working with and caring for patients in Nevada. There are oftentimes different interpretations of statute, and this clarifies it for these entities to be able to provide the needed care to patients here in Nevada. So again, I support this. Our association supports it. Thank you.
Thank you for your testimony. BPS, next caller.
Chair, we have no additional callers in support at this time.
Thank you, BPS. I will now move to testimony in opposition. I'll start with Carson City. Is there anyone here wishing to testify in opposition? Okay, seeing none, we will move to Las Vegas. Is there anyone in Las Vegas wishing to testify in opposition? Seeing none, BPS, may we please check the telephone line?
Chair, the line is open and working, but we have no callers in opposition at this time.
Thank you. I will now move to testimony in the neutral position. Is there anyone in Carson City wishing to testify? Is there anyone in Las Vegas wishing to testify in the neutral position? BPS, can we please check the telephone line?
Chair, the line is open and working, but we have no callers for neutral at this time.
Thank you, BPS. Chair Marzola, would you like to give any closing remarks? Okay, at this time, I will now close the hearing on Assembly Bill 110. 1 minute recess.
I will now open for public comment. Each person has 2 minutes to provide testimony. Is anyone here in Carson City wishing to test or give public comment? I don't see anyone. Is there anyone in Las Vegas wishing to give public comment? I don't see anyone. Broadcast, is there anyone on the line wishing to give public comment?
Chair, the line is open and working, but we have no callers for public comment at this time.
Thank you. Committee members, are there any questions? I don't see any. Our next meeting will be Friday, March 3rd at 1:30 p.m. We are adjourned.